Welcome to our webinar. SB-793 is the law. Now what? We are the Law and Policy Partnership to End the Commercial Tobacco Epidemic, and the partnership is the teaming up of the American Lung Association and the Public Health Law Center to support tobacco control professionals in their work to end the commercial tobacco epidemic in California. I am Jamie Long. I'm a senior staff attorney with the Public Health Law Center. And the Public Health Law Center is located at Mitchell-Hamlin Law School in St. Paul, Minnesota. We acknowledge that we are in the indigenous homeland of the Dakota people, also known as the Sioux Nation. We appreciate the ongoing stewardship, spiritual connections, and lifeways developed in these homelands upon which this law school sits. The Public Health Law Center provides technical legal support. We provide webinars like this one. We provide trainings, but we do not lobby and we do not provide direct legal representation. We also center all of our work in health equity. We are committed to removing all institutional barriers and applying an equity lens to our work to produce the best results for the communities we serve. So today we're here to talk about SB-793. And this law passed way back in August 2020. We're going to talk a little bit about what the law does, talk about local options for governments in California now that the law is in effect, and then talk a little bit about next steps, the path forward from here, and then we'll get to your questions. So the law bans the sale of flavored tobacco products. It does not criminalize possession. It's just focused on the sale. And this is only the second state in the country that has taken broad action to prohibit the sale of flavored tobacco products after Massachusetts. The law covers tobacco retailers, their agents, and employees. And so it makes selling from a retail location or vending machine a flavored tobacco product against the law. So a retail location is defined as a building from which tobacco products are sold at retail. So there have been some questions that came in ahead of the webinar and in other conversations about what online sales might be covered. And so the best interpretation we have is that online sales would be covered if they're selling from a retail location. So if you have a building that is selling tobacco products at retail, it should not matter if that sale is happening with an online purchase or with money being exchanged there. The bill also covers mint and menthol flavors. This was a big win. There was quite a lot of tobacco industry lobbying to try to exclude menthol. We know that menthol cigarettes are the source of addiction for nearly half of all teen smokers. And we also knew that 85% of Black smokers use menthol versus 29% of white smokers. So there is a significant health equity win in making sure that menthol is included. And we'll get in a little bit more to some of the bill coverage in just a minute. So what happened to the bill after it was passed was a referendum was submitted by the tobacco industry. They were the top three funders, as was required to be publicly disclosed under state law of the referendum effort. They received the minimum required number of signatures, so it qualified, and the law was put on hold from August 2020 to when it went on the ballot just a couple of weeks ago. And as folks on this call, I'm sure know, the result of the referendum was that voters said that they wanted the law to move forward by a vote of 63% yes to 37% no the last I had checked. So the results have to be certified by the Secretary of State by December 16th. There are still votes being counted in California, so certification is not imminent, but that means that under state law, the SB-793 will go into effect 5 days after certification. So the latest certification or the latest date by which SB-793 will go into effect is December 21st. So now I want to talk a little bit about some of the exemptions that are in SB-793 and some of the coverage scope. So there are three main exemptions in SB-793. The first is for hookah and shisha. And it does not exempt all hookah and shisha products. It only exempts them if they're being sold by a business that's licensed to sell tobacco products, where no one under 21 is allowed, and they were complying with all rules for tobacco retailers. The bill also still covers electronic hookahs, so those are not exempt from the flavor sales prohibitions. There also is an exemption for premium cigars, and premium cigars have a lot of criteria they have to meet to be under this definition. So the first is they have to be over $12 per cigar. So this is not, we're not talking about cheap flavored cigars like you might see in your local convenience stores. They also have to be handmade. They have to have a tobacco leaf wrapper. They cannot have a filter, a tip, or a non-tobacco mouthpiece, and they have to be capped by hand. The bill also includes a second exemption for premium cigars that are sold in a cigar lounge and consumed on premises. And there's a lot of overlap between those two exemptions. The third is for pipe tobacco. And so this applies to loose leaf tobacco, defined to include cut or shredded pipe tobacco, usually sold in pouches. This would not then apply to tobacco products suitable for making cigarettes, including roll-your-own cigarettes. So here is a handy chart about the different covered products and exempt products. So covered products include menthol cigarettes, chewing tobacco, snuff, little cigars, cigarillos, e-cigarettes, roll-your-own tobacco, and flavor enhancers. And then the exempt products are the three that I just went through: hookah and shisha, pipe tobacco, and premium cigars. It's worth reminding our audience today that there is no safe tobacco. Hookah, in fact, research shows, may pose a greater risk to human health than other combustible tobacco products. And contrary to common misperceptions, hookah water does not filter out toxins. So hookah is still a very toxic product. Cigars as well have major health implications. One large cigar can contain the nicotine equivalent of an entire pack of cigarettes. And pipe smoking is known by researchers to increase the risk of several types of cancer. As the American Cancer Society notes, there is no safe form of tobacco. So all three of these exemptions are not ones that we would consider pro-public health. But the good news is that there is no preemption under SB-793. It is explicit in the law that any local government can pass a stronger restriction than SB-793 currently has. And there are currently 134 California jurisdictions that have enacted flavor bans. So all of those bans will remain in effect, even if they are stronger than SB-793. And there are a large number of jurisdictions in California that have what we would consider to be comprehensive flavor bans, where they are covering all products with no exemptions, all flavors with no exemptions, and all places as well. So this is a chart that was taken from one of our publications that I'll show an image of in a second, that tracks the flavor policies for all jurisdictions in the country, over 75,000 people. And as you can see, there are a large number of jurisdictions in California that already have what we would consider comprehensive flavor bans. And that's continued on this slide. So you can see the large number of California jurisdictions, including some big ones like Los Angeles County, Santa Barbara County, Sacramento County, that cover the entirety of the products that we would consider best practices for public health. And if you're interested in looking up your own jurisdiction, so long as it's over 75,000 people in population, then this publication, which we updated this past April, tracks all of the existing local flavor policies across California and across the rest of the United States. So what options do local governments have now that SB-793 is going into effect? Well, the first option is if a local government does not have a tobacco retail license policy that they have passed, now would be a really good time to do so. The image here is our model policy that the partnership has put together for comprehensive tobacco retail licensing ordinance. And in our model policy, we include a flavored tobacco sales prohibition. So enforcing a flavored tobacco sales prohibition through a tobacco retail license, we consider to be a best practice because it gives local jurisdictions a lot of different options for enforcement. So in our model policy, for example, we include fines as a possibility, also the possibility of having suspensions or revocations of the license itself, and many other options. And if you're interested in getting into enforcement options for tobacco retail licensing, we have a separate publication that we have published on equitable enforcement for TRLs, and we recently did a webinar on that topic as well. The second option is if you have already adopted a TRL or a local flavor policy, you can now update it to close the loopholes that are present at the state level. As was mentioned, there is no preemption of local governments going above the requirements of the state law. It is just setting a statewide floor. So any local government can choose to close those loopholes. And we have many publications about the health equity reasons to close the hookah loophole in particular. We have done webinars on that topic as well. So if you'd like more information on hookah, you can check out the Public Health Law Center website for good data and research and information about why hookah is harmful and should be that loophole should be closed at the local level. The other option that you might have is to incorporate enforcement of SB-793 by reference. So if you have a local tobacco retail license policy already, our model policy includes language that says any violation of a state tobacco law is also a violation of the local tobacco retail licensing ordinance. And so that would mean that if a retailer were to violate SB-793, then that would open up those other enforcement options that I talked about for your local TRL. And so that could include license suspension, license revocation, or any of the other local enforcement options that might be in your TRL to deal with those policies. So that would be something we'd consider a best practice because it would give additional options for local governments to enforce against retailers that are not complying with SB-793. And then a fourth option is that local governments can enforce SB-793 on their own. And so I'll go to dig a little bit more into that topic. So as was mentioned, SB-793 sets a new floor statewide, and but it does not have a ceiling, so local governments can go above it. But now, even if a local government does not have a flavor policy in effect, they do have a flavor policy that they can enforce, which is SB-793. And the law does not specify which local entity should enforce the law. So each community will need to decide the agency that is best suited to enforce. And as was mentioned, we do have a publication on different enforcement options that could be a helpful resource as you're thinking about the types of approaches you may want to take for enforcement. But the primary jurisdictions that will be enforcing the law will be local. So they will be counties and cities. The state entities are not specified for enforcement in the law. So this is going to be a locally enforced provision, at least as of now. So once the SB-793 goes into effect, as was mentioned, December 21st would be the last day that would happen. Retailers must remove products from their shelves, flavored products, and they must stop selling those products. So there is some lead time, but not that much for retailers to start complying. And they know right now that December 21st is going to be that last day on which they might be able to sell these products in the state of California. Under the law, the penalty for violating SB-793 is an infraction with a $250 fine per violation. So if a local government is enforcing SB-793 then this is the penalty that they will be able to enforce. I also wanted to mention that when we're thinking about the disposal of potentially a large amount of flavored tobacco products from some retailers that may have continued to stock them, then tobacco product waste is an important consideration. And electronic cigarettes in particular are likely hazardous waste under California and federal law because nicotine itself is a hazardous waste product under EPA regulations. So local retailers may be hazardous waste generators under the Resource Conservation and Recovery Act at the federal level. And if they are generators, then they need to be disposing of these products in hazardous waste collection facilities, not in the regular trash. There are different requirements under federal law depending on the quantity generated. And we have an FAQ document on our website that goes into tobacco product waste requirements. But the basic one to know is you can't dispose of, if you are a business, it's different for individual households, but if you are a business, you're not going to be able to dispose of electronic cigarettes in the regular trash. You're going to have to dispose of them in hazardous waste collection facilities. So the last topic I'm going to cover before we get to questions is litigation. So the slide that we showed earlier with all of the jurisdictions that have passed flavored tobacco policies in the state of California shows that there already have been a lot of jurisdictions moving in this area. So there have been some lawsuits that have been filed against those jurisdictions, including in San Diego and in LA County. And RJ Reynolds versus LA County went up to the Ninth Circuit, which is the federal court of appeals that covers the state of California. And in March of this past year, they ruled on that case. The challenge was based on federal preemption argument under the Federal Tobacco Control Act. So I won't go into a whole lot of depth on the argument here, but and if you're interested, we do have write-ups on our website about the case and the arguments. We also, Public Health Law Center, filed an amicus brief in that case. But the Ninth Circuit did rule against the tobacco industry and found that there was no federal preemption of Los Angeles County's flavor ordinance. So that meant that LA County could move forward with its flavor policy. This has also been the finding in every federal court that has taken up this question to date, and there have been lawsuits in Illinois, in Minnesota, in New York, and Rhode Island, and several of those have also gone up to the federal circuit level. So to date, the tobacco industry has had a track record of losing these lawsuits, but at least for the purposes of California, because this was a Ninth Circuit decision, the RJ Reynolds versus LA County case is binding precedent in California. So why then, you might ask, did RJ Reynolds sue just this past month after the election results, the state of California over SB-793? Well, the answer is that they are hoping to overturn this binding precedent through the Supreme Court. And so they, in the filing, which is the case is RJ Reynolds versus Bonta, they acknowledge that this RJ Reynolds versus LA County is binding legal precedent, that they don't have a claim that would be successful because of the March decision by the Ninth Circuit. And so just on earlier this week, they agreed with the state to dismiss the motion that they'd filed for a preliminary injunction, so a motion to stop SB-793. They agreed that motion was not going to succeed, and they just agreed not to even brief the case, but just to go ahead and reserve the right to appeal. So the court did find that there was a binding legal precedent, that they could not succeed with their preliminary injunction motion. And so that case has now been appealed as of this week to the Ninth Circuit. So what does that all mean? Well, that means that as of right now, SB-793 is still in effect, that there is not right now a claim within California that is going to lead to SB 793 being put on hold with a preliminary injunction because of the binding precedent from March in the LA County case. And so therefore, the law will go into effect on December 21st. There still may be continued appeals to the Supreme Court in the LA County case, or in the Banta case, which is going right now to the Ninth Circuit. So that is the quick overview of where we're at right now, and happy to take questions. I'm sure we have lots.
All right, we do have quite a few here. And I do want to get started with a couple that came in earlier. One asked about the definition of a violation, and does per violation mean per product, per day, each time they're visited by enforcement agency, and also where is the fine payable? Is it payable to the court, or who gets the money?
Sure. So the per violation is a violation of the law, and the law is selling a flavored tobacco product. So that will be up to your enforcement officials to interpret. But if they're selling a flavored tobacco product, that's going to be a violation of the law. The fine, that's a good question about where the fine is payable. I'm not actually 100% sure, but we can look into that and get back to you.
Definitely. Another question that came up talks about products not sold in buildings, but rather with mobile delivery services and stores. Do we know if the law is applied to tobacco sold in those types of delivery services?
So it covers the products that are sold from tobacco retailers, and that is defined under the law as a building. And so that is that's the current definition of SB 793. But there are different local definitions, and a lot of local governments have restrictions on doing delivery sales. So you would need to look at your local rules as well as the state rules to figure out delivery. There's also both federal and state law that is separate from SB 793 that applies to delivery sales. So there may be restrictions aside from SB 793 on delivery.
All right, our next question is a clarification on local law enforcement. You talked a little bit about this in your presentation, but is it only local law enforcement that can enforce SB 793, or can other environmental health agencies or other agencies do anything about it?
That's a good question. So it is not specified in SB 793 what the enforcing agency needs to be. So that will be a determination that each local government needs to make about which entity in their local jurisdiction can enforce the law, or would be the appropriate one to do so.
All right. Next question is, someone said that in their work, they provide educational model tobacco retail ordinances. And will those types of documents need to be updated in light of the proposition passing?
So they certainly could be. I think for our tobacco retail license model ordinance, the primary things that we would want to see local jurisdictions adopt as best practices are already in there. So that includes incorporating by reference violations of state law, and then closing the loopholes that are at the state law. So our tobacco retail license model ordinance that we have posted on our website is up to date for those needs. But we're certainly happy to work with individual jurisdictions that have specific needs or want to update their model policies based on the SB 793 change.
Yes, really happy to help with that. This is an interesting question about discounts. Will retailers be able to discount their products to sell them or get rid of them before December 21st?
So SB 793 itself doesn't speak to discounts. There may be local laws that prohibit discounts, and so you need to check with your local jurisdiction laws to see.
Okay, time for, I think, a couple more here. So someone said for the hookah exemption portion, being that retailers must only allow 21 plus people of 21 years or older to enter, is there a definition that requires the entire store to follow suit, or can stores set a specific section of their store as like an adult only section? And this person says that this has been an issue in some California jurisdictions with local flavor policies.
Yeah, that's a good question. I'm not sure that it's 100% clear from that it has to. I don't think the SB-793 specifies that it has to be a standalone building. So there may be some creativity from local retailers in that point. And I would say if that's something you're concerned about, then it's very easy to close that to be more specific than SB-793 is in your local law. And a number of jurisdictions have done that at the local level, where they are specific about what types of hookah exemptions they might allow. LA County or LA City would be a good example to look to about a jurisdiction that has some real specific requirements around hookah. But as I mentioned before, hookah itself is not a safe product, and there are a number of health equity and other concerns with hookah. So the best practice from a public health standpoint would be to close the hookah exemptions altogether. And we have some good resources for you about the research on that and why the hookah exemption loophole should be closed.
Thanks for that, Jamie. I think we have time for one more here. And this person said that, so our county DA is wanting our public health department to take lead on classes and trainings for retailers on tobacco laws. Can this be an activity covered through a tobacco retail license, especially now that we will have to include elements such as SB-793?
So yes, if you write your one of the things that we encourage in our model policy is for local jurisdictions to set up the fee structure to cover all enforcement activities. And it does seem like an appropriate enforcement activity to include public education. We know that education is often a lot better on the front end than doing enforcement on the back end, and you're going to get more compliance. So we would recommend writing your policy so that the fees have to cover all enforcement costs, and can certainly work with jurisdictions on that. We also have a fee calculator on our website to think through setting up local TRL fees. So if that's our last question, then I'll just close by saying that we know that this is a hot topic. We know that there are going to be lots of questions, and you may not have had your question answered today. We wanted to try to do a quick 30-minute webinar so that folks could get a lot of their questions answered. But please don't hesitate to follow up with us if you have additional questions, and we would be happy to help get them answered, and appreciate that this is a big moment for California and for a lot of jurisdictions that may not have flavor policies as well, and are now going to be entering into the exciting world of flavor policy enforcement.